The 2018 Team Canada essay trial has officially ended. This is part one of the last day of the court proceedings. If you're new here, I've been covering this trial the entire way. I have videos of every single day, so make sure you go watch those and follow for the verdict. The Crown lawyer started the day by saying that the Crown has to prove that each of the 5 men on trial knew that EM didn't consent to sexual activity or that they are willfully blind or reckless in assessing her consent. He then said, quote, if they believe that consent can be given in advance, or that as long as she didn't say, quote, no, she was consenting, or that consent does not need to be for specific acts, or a belief that consent to someone else's consent for them, none of them are consent in the law. Reasonable steps must be taken to get consent. The law states, in quote, greater care must be taken to get consent if the parties are strangers to one another or if the complainant is drunk or vulnerable. Quote, if a reasonable person would have taken more steps than the accused, the defense fails. The lawyer told the judge that, quote, at no time did anyone engage in a sincere conversation with EM about what she truly wanted to happen. At no point does anyone say, do you want this to slow down? Quote, your honor has heard from the men in the room that all of them thought her conduct was on some level bizarre, strange, or outrageous, but no one asked her, are you feeling okay? Is this really what you want to be doing? She then said, the videos are not evidence of consent. They're, quote, token lip service box checking that is not a real step to a certain consent. She said, quote, she's naked on her knees with the men talking around her. Mr. Hart saying, I'll get fabs, I'll get fabs. She's wiping her eyes. That is not a reasonable step to a certain valid consent. Then went on to say the second, quote, consent video in which EM is naked and holding a towel over her torso begins with McLeod saying, quote, say it. EM has said that she didn't remember the videos were recorded, but that when she watched them, it brought back a memory of McLeod, quote, hounding her to say that she had consented, and she said that to, quote, get out of there. He then says, quote, what else? In the video, she says it was all consensual and that she was fine and that she enjoyed it. The Crown said that McLeod was, quote, directing what EM should say. Crown then said, if she's begging for sex, wouldn't she say something like that? Saying, quote, it was fine, I enjoyed it, doesn't reflect EM's supposed enthusiasm for what took place. The lawyer then also added that McLeod texted EM on June 20th, 2018 and told her to call police and tell her mom's reported sexual assault was a, quote, mistake, which is another example of him, quote, directing her what to say. At that point, the Crown attorney then passed the case over to the assistant Crown attorney, who took the judge through the, quote, credibility and reliability concerns of each man's case. She says that the recurring theme of the defense case is that the men thought EM was consenting through her words and actions, and that they thought interest in general sexual activity is consent to other specific acts.